Today, I want to get straight to the point. There is a huge misunderstanding spreading online about Constitutional Court Decision 142 of 2025. But before we begin, I want to tell you something important. At the end of this video, I will share a personal reflection with you. It's the same message I try to transmit in every single petition I file in court. It's something I have never said publicly before, so I invite you to stay with me until the end. Because if you care about your right to Italian citizenship and your children's right to inherit, you need to hear it. Now, let's clarify what Decision 142 really does. Many people believe it rewrote the 2025 reform. It did not. Many believe it validated the so-called minor issue. It did not. And many believe it blocked judicial recognition of Italian citizenship. It absolutely did not. What this decision actually does is far more important. It sets the constitutional framework the court will use in the next rulings. And those rulings will decide the future of jus sanguinis and the future of the 2025 reform. But before we go deeper, if you want clear and real legal updates from an Italian lawyer, not rumors, not fear, not social media panic, please subscribe now and hit the bell. The next weeks will be crucial for everyone with an Italian citizenship case. Since so many of you appreciated my breakdowns of the Padua and Turin referrals, today we focus on only real constitutional court decision issued after the reform. Decision 142. And in this video, we go deep. We analyze what it really says, what it does not say, and how it will influence the court's next steps. My name is Carlo Pontei, and I am an Italian lawyer specializing exclusively in judicial recognition of Italian citizenship. Let's begin. Decision 142 does not examine the 2025 reform. It does not address Article 3 bis, and it does not touch the minor issue. It comes from four referrals: Bologna, Rome, Milan, and Florence, all raising the same fundamental question. Is unlimited jus sanguinis still compatible with the Constitution today? These judges asked the court to review the basic rule that the child of an Italian father or mother is an Italian citizen at birth. Their concern was simple. After many generations abroad, is this rule still reasonable? The referring courts raised several constitutional doubts. They questioned whether unlimited jus sanguinis still reflects the identity of the Italian people. They argued that it creates tens of millions of potential citizens with no real connection to Italy. They invoked the international principle of effectiveness of citizenship, and they compared jus sanguinis to other pathways that require stronger ties. This is the background. Now, what the Constitutional Court actually says is far more nuanced. The court reaffirms key constitutional principles. It confirms that citizenship by descent is an original mode of acquiring citizenship. It is rooted in the parent-child relationship. It is closely connected to personal identity. The court recalls the Supreme Court's view. Citizenship by descent is permanent imprescriptible and not dependent on residence or cultural ties. This is a strong message. Citizenship by descent is a status from birth, not a discretionary privilege. The court then explains that the referring judges were essentially asking it to redesign the entire system, to impose generation limits, to require stronger ties, to restructure the whole model of citizenship. Well, the court refuses. It says clearly, these changes are for Parliament, not for a constitutional judge. This point will matter enormously when the court examines Article 3 bis. The court also rejects the idea that jus sanguinis violates equality. It explains that citizenship by descent serves a different function from other pathways. Therefore, it's not discriminatory. Just as important is what the decision does not address. It does not examine the 2025 reform. It does not evaluate Article 3 bis. It does not consider retroactivity. It does not analyze the minor issue. It does not discuss dual citizens born abroad. The court states plainly that the new law does not apply to these other cases, and therefore the court cannot judge it. For this reason, decision 142 cannot be used to support the reform, and it cannot be used to challenge it. It simply does not deal with that topic. But the decision is extremely important for the future because it sets the principles the court will have to apply when it finally reviews Article 3 bis. The court emphasizes that citizenship is part of personal identity. This is crucial because the reform attempts to treat many people as if they had never been citizens at all. The court recalls that the legal system must protect legitimate expectation. This principle will be essential when the court examines the retroactive lack of acquisition mechanism. The court also insists that major structural changes cannot come from judicial creativity. They must come from Parliament, and they must remain within constitutional limits. And the court rejects the idea that the size of Italian diaspora threatens Italy's democratic identity. This weakens one of the key arguments for restricting jus sanguinis. Looking ahead, several outcomes are possible. One possibility is that the court upholds the reform entirely. This is possible, but constitutionally delicate, especially regarding minors and retroactivity. Another possibility is that the court upholds the reform only in part. It could allow new rules for the future, but strike down retroactive effects, especially where they function as retroactive laws of citizenship. A third possibility is that the court strikes down the most problematic parts, especially those affecting minors, those removing citizenship without due process, or those erasing a status that existed from birth. Whatever the outcome, Decision 142 will guide the court's reasoning. If you have a case pending, if you filed before the reform, or if you are trying to understand whether you can still file, do not rely on rumors or social media. Every case has its own dates and documents. A single detail can change everything. If you want a personalized analysis of your family line and your legal options, you can book a consultation through the link in the description or directly on our website, mangataavvocati.it. We have already analyzed other crucial developments, such as the recent referrals from Mantua and from Turin. If you have not seen those videos, I strongly encourage you to watch them because they are absolutely essential to understand what is happening right now. And in the next video, we will continue to analyze every important ruling, every reform, and every new judicial development, because all of you deserve to know how to defend your right to Italian citizenship and the right of your children to inherit. Now, I want to leave you with a personal reflection, a message dedicated only to the bravest among you who have watched this video until the end. In fact, write a comment below to let me know if you made it here, because otherwise I will start making shorter videos. My thoughts go to our ancestors. And in many ways, that means our past selves. To those who left Italy for any reason, but who always believed that their children and their grandchildren will remain Italian forever. And yet, today, sadly, that is no longer certain. Remember this, you are not only the holder of the right to Italian citizenship, you are also the holder of the right to transmit that citizenship to your descendants. This is one of the reasons why I find the so-called citizenship by benefit of law deeply problematic. What does benefit of law even mean? I'm Italian, therefore my children and their children are Italian. We were born with this right. No law should be needed to grant it. No law should be allowed to take it away retroactively. Tell me if you agree with this. So, thank you for watching and see you in the next breakdown.